Hi, good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by Mohamed Hashim. He's here to talk to us all about the License Appeal Tribunal and a few other things there we'll get to as well. So, Mohamed, nice to have you here. Maybe you can start by telling us a little bit more about your practice and a little bit about your journey there from law school to where you are today, in a nutshell.
Well, thanks so much, JP, for having me. First of all, legally, are we allowed to talk about anything else other than the Chris Rock Will Smith slap? I thought that is the only thing the internet is allowed to do for the next 48 hours. I assume
I
that's
feel
why
like
I was on here. No?
I feel we could have a whole special on that. We get the plaintiff civil side. You can have a criminal law perspective, right?
There
I
you
mean,
go,
that could be
right?
like a whole law school course. I mean,
That's right.
imagine Amir Mohammed teaching us, the effects of Will Smith and Chris Rock. There,
I feel like we've stumbled on $1 million idea here.
No, I mean, I don't know how we can even transition from there to about you, but tell me then how you got to where you are today and what you're doing.
Sure. No, obviously I'm just joking around, but again, thanks for having me on here. My name is Mohamed Hashim, Senior Legal Counsel at Aviva Trial Lawyers. So I'm in-house counsel at Aviva doing insurance defense work. Before that, I went to law school at the University of Windsor. Before that, I went to York U and did a political science undergrad. I think that was all the rage back in the day. The guidance counselors everywhere were telling you if you wanted to be a lawyer, you had to have a political science undergrad. So I filled that cookie cutter mold pretty squarely. So I've got a poli-sci undergrad from York, University of Windsor law degree. I went to U of T and did an LLM. So that was kind of fun, stretched the academic muscles. And I summered and articled at a firm called Heenan Blakey, may it rest in peace, even though I'm sure most of your audience or most of the legal profession will know what Heenan Blakey was. But that was a lovely experience there. And I'm one of those few students that did, after law school, I did articling, an LLM, and I also did a clerkship. So I spent a year at the federal court working under Justice Roger Hughes. So I spent some time as a judicial law clerk for a year. And then afterwards, I transitioned into insurance defense work, which is pretty odd, because if you ask any law student, going into law school, what do you want to be, or what kind of lawyer do you want to be? I guarantee you most of them are going to say, I want to be a constitutional law lawyer, or I'm going to be a criminal defense. I'm going to be that guy in A Time to Kill, Matthew McConaughey, and give that passionate speech. Nobody says, you know what I want to do, JP? I want to be a first-party insurance defense litigator arguing in front of a license appeal tribunal. I'm pretty sure none of us could have even spelt the license appeal tribunal back then, because we had no idea what it was called. So the trajectory that I had is just this huge curve. It wasn't a straight line. It never really is for, I think, any of the law students. And so I'm happy to talk about that in greater depth, because on the one hand, there was thoughts of being in academia, and then on the other hand, there was thoughts of being in intellectual property. You and I have a history, once upon a time, meeting at an intellectual property moot once a few years back. Then I go from IP to insurance defense, and I'll say this, and it sounds like a cliche, I wouldn't have changed it for a thing. It's been a lovely ride.
Perfect. That's great. I mean, I think, again, going back to when we were in law school, I think, just like you had the political science background, you were kind of told, Bay Street and that's it, sort of. I mean, it seemed like that. I mean, maybe you weren't exactly told, but that's what it seemed like it. And now it's good to have people like you that have, hey, they're not going to have a question about what the license appeal tribunal anymore, because you're going to tell us all about that. But before we get there, I think it is important to look at that trajectory there. And maybe you can talk to us either. I mean, you got in at Heenan Blakey and all of that happened. And then, academia, the clerkship. How did that kind of, what was the order in that sort of came out? And maybe you can tell us a little bit more about that.
So when I got into law school, I was all about constitutional law. My undergrad in poli-sci kind of laid the foundation to want to know about the Charter of Rights and everything constitutional law. So when I got into law school, I had a straight line in my head. I was going to work for the DOJ. I was going to be the next Peter Hogg, and I was going to just be that guy. And it's funny because you have that blueprint in your head. Like you said, you go in and you have kind of like what you feel the expectation is. The expectation is to go to Bay Street, get the job, get the title, get the money. But when you learn, when you go through other programs, go through classes, and you realize that there's more to law than just the Charter of Rights and Freedoms, there's more to your practice than just litigating in certain niche areas of law, then your universe expands. And for me, that's what happened. I in my second year of law, I got involved with intellectual property. And you mentioned Dr. Amir Mohamed. He was a professor at University of Windsor back in the day at that time. And he was doing a lot of intellectual property classes back then. And I took a couple of the classes, and it really spoke to me. It was very compelling work. I was drawn towards it. And in that time, there wasn't a moot about intellectual property. And I'm sure your students and everybody who's like, a moot is basically just a glorified version of a mock trial. And when I was in law school, there was only about 6 or 7 kind of standardized mock trials. There was the constitutional law one, there was the criminal law one, there was one on, I think, labor. But if you had said, what about patent law or copyright law or, trademarks, everyone kind of look at you kind of funny and go, we don't do moots for that. And so he and I had set out in my second year to kind of create one of those. And through a lot of hard work and, blood, sweat, and tears, we co-founded the Harold Fox Intellectual Property Moot, which I'm proud to say is still ongoing now. I'm no longer involved in it, but I'm a proud co-founder. In my second year of law, that's what I was doing. And it was a labor of love. And it was something that, it for me is an example of, you go in thinking one thing. I went into law school thinking constitutional law, and then I did a right turn, so to speak, and I went and started learning about intellectual property. And so in my second year of law, I'm all of a sudden dubbing myself, well, I'm going to be an intellectual property lawyer. I'm going to be a pharmaceutical patent litigator, JP. That's the kind of guy I'm going to be now. And at the time, I was going through the OCI process, the on-campus interview process, and I had a resume that reflected constitutional law and a resume that also reflected intellectual property. And so during the on-campus interview process, I was courted by both DOJ and by a few Bay Street firms. And I remember it's called call day. I'm sure your audience knows, at 5 p.m., the calls come in and they say, we would like to offer you a position. And at 5 p.m., I got a call from both the DOJ and Heenan Blakey. And I had to make a decision, what kind of lawyer I'm going to be. Am I going to be a constitutional law lawyer, like I said I was going to be when I, walked into York University, or am I going to be this new lawyer, this Bay Street lawyer that I keep hearing about when I'm in law school? Everyone says, you got to be that guy. What's the show Suits? Everybody wants to be the main guy in Suits. And so I had to make a decision. And with the help of my family and the support of my friends, I mulled it over, and I chose Heenan Blakey. I said, there's more law in that private space, whereas at DOJ, you're only going to be that kind of lawyer. And so I made a choice to kind of follow an expansion of my universe, to kind of see what else is there other than the cookie cutter law that I was told at the beginning of law school. And so I went to Heenan Blakey and had a wonderful time, met Jean Chrétien, who was formerly counsel over there. That was kind of cool to meet him. I can't say that we're buds. He just shook my hand, said, "Nice to meet you, young man." But, I get to say I met him. So there's that. And I had a wonderful time. Fantastic experience. I've made some friends that have endured even to this day. Some really, really close colleagues over there. But while I was at Heenan Blakey, I was also part of the IP moot. And during that time, I got to interact with some of the judges at the federal level. And I remember in second year, there was talk about if you want, you could apply for clerkships and you could work with these judges. You could either be in a superior court, you could even go all the way to Supreme Court, you could go to the federal court. And, I thought of that idea as something really invaluable, because the experience you gain learning at the foot of a judge is something that, most lawyers would, jump for. So in my second year, I applied also to be a judicial law clerk. And thankfully, I got called into an interview with Justice Roger Hughes, who's now since retired. But it was a mind-opening experience in terms of not only the interview, but just the time that I spent in Ottawa. And so I got the job, thankfully, and I agreed to take on the role. And it was one of those things that I firmly believe was one of the most invaluable experiences of my career. Even the interview, I'll tell you, there was a moment in the interview where he's telling me what his expectations are. And he says, "Young man, I'm going to need you to do this. And then I'm going to want you to do this. And then I'm going to do," and he starts rattling off about 5 or 6 different line items. And, you know, my young law school mind is going, oh, okay, I gotta do this. And then I'm going to do this. Okay. Then he wants me to do this. And so he finishes his kind of like, "These are my expectations for you." And so I look back at him and I go, "Okay, how fast do you want that turned around? Like, what's the turnaround time?" Which is something most law students are pre-programmed to ask when you're given instructions. You know, how fast do you want it back? And he leaned over and he goes, "As fast as you can." And it was one of it was one of those moments where I go, oh, it's not like they teach you in law school where you have a deadline and then you have to do it this way, and then the next assignment is coming over here. This is real life. This is somebody needs something and they needs it as fast as you can do it, right? And so that's kind of like my anecdote to recognize, hey, wait a minute. School's great. They teach you all the fundamentals. But when you get out of school and you start learning and your universe expands, you start to see things in a different perspective.
Yeah. So now your universe, you get out there, you do the clerkship, you go to Heenan Blakey, you made this decision, right? I mean, I don't know how long you had to mull it over with those call days. I mean, not as much as probably you would have liked to. And you're generally happy with the decision. You got to shake John Kretschman's hand. Everything's going well. And then what happened?
Okay, yeah. So everything's roses, it sounds like. And you're right, I didn't have much time. It was, call day is such a hectic experience. I had maybe all of 5 minutes to make a decision that would shape the career of my life when I had to decide between DOJ and Heenan. But after I finished articling, I politely told my principals at Heenan Blakey that I wouldn't be coming back and that I was going to pursue the clerkship. So after I finished articling, I joined the federal court. And during the federal court's time, I witnessed some of the best advocacy that I've ever seen. These are the creme de la creme of some of the Bay Street litigators that came through. I don't know if you remember, once upon a time, now we take it for granted, but when I was there was this company called Wind Mobile, which is currently now Freedom Mobile. But back in the day, Wind Mobile was trying to get into the Canadian market. And Canada Telecom is a highly competitive, some might even say monopolistic industry, because it's controlled by, a select few of companies. And here comes this kind of plucky upstart Wind Mobile and says, we want to get into the cell phone industry space. And Rogers and TELUS and Bell all got together and said, wait a minute, Wind Mobile, you're not fully Canadian. And in order to be a Canadian cell phone service provider, you have to have the majority of your stakeholders Canadian. And so they challenged it, and it happened to come across my desk. And I got to see, some of the top lawyers representing Rogers, Bell, TELUS, Wind Mobile, with literally billions of dollars at stake, because the cell phone industry is one of the most lucrative industries on the planet. And I got to see that advocacy. And it's intoxicating, JP. I won't lie to you. You look at that and you go, oh man, I'm just eating my popcorn just watching it. And I had a judge who was fortunate for me, who really involved me. I got to sit literally in the witness box to watch all of it take place. He wouldn't have me sit anywhere else. He said, you're going to sit here, you're going to take notes. I was in the chambers with him and we were bouncing ideas off of one another. And, what do you think about this case? And did you see what that guy said? And, that guy's suit didn't really match his socks. Some of the, you get the good and the bad of the commentary, but you hear everything. And so it was one of the best experiences of my life. And the advocacy was intoxicating. And so I finished my clerkship and I set out in my head, you know what? I got to be one of these guys. I got to be one of these litigators, these Bay Street high litigators. And I will tell you, I applied for about 6 months, different firms here, there, and everywhere, both in Toronto and in Ottawa. And I interviewed all over the place. But right around that time, the economy collapsed, right? That was subprime mortgage, and everybody was feeling the effect of that. And all of a sudden, the things started to get a little dicey economically, and suddenly large-scale corporations didn't want to pay big-end law firms for an army of lawyers. They'll pay for the high-end partner, they'll pay for the second chair, they might even pay for the third chair. But for the law student who just got out of law school and finished his clerkship, who wants to be part of the team, the corporation said, well, we're not paying for your fourth and your fifth chair, so we really don't need that lawyer. And that trickles down, right? Because if the client doesn't pay for the lawyer, then the firm is not going to hire that lawyer. And so that's where I was. I was faced again at another kind of crossroads, which is, do I keep pursuing this kind of image that I've been chasing? This idea of who a lawyer is and what that lawyer looks like, especially in the type of law. Oh, I'm going to be this space of a lawyer. And I had a real kind of moment of clarity, where I realized, wait a minute, there isn't one type of lawyer. There's other types of lawyers. And it was actually a colleague of mine at the federal court who said, you know what you would love, considering your love of advocacy, is you would love insurance defense work. Because, and I didn't know this at the time, and I guarantee you a lot of students don't know this at the time, if you want to be a litigator, you should be in either plaintiff injury or insurance defense, because you are going to be on your feet in the trenches almost from the moment you're called to the bar or from the moment you're licensed. Like it is right there, right on the ground floor. And I didn't know it until someone told me. And then I started digging in and investigating it a little bit more. And I realized, oh my God, she was right. She was absolutely right that this area of law is what I've been craving for. From the moment I wanted to do the IP moots and start that advocacy journey, from the moment I witnessed the advocacy at the federal court level, all of this passion was bubbling up inside of me. And I realized I should just be litigating. It doesn't matter what area, doesn't matter what firm, doesn't matter what it is. I just want to be on my feet litigating. And that leads me to where I am now, which is I'm practicing in first-party insurance defense litigation. And the vast majority of my cases that I argue is in front of the License Appeal Tribunal. And again, if you had told me as a law student, or you told any law student, what's the License Appeal Tribunal, they'll look blankly at you and say, I have no clue what that is. That sounds like a made-up tribunal. Because when you're in school, you're designed, well, I'm going to argue in front of the Supreme Court of Canada, and I'm going to bow, and I'm going to wear the robe, and I'm going to do all this fun jazz. That's not what it is. It's a romanticized version of what advocacy is. What advocacy truly is representing the interests of a client to the best of your ability. And if you want that, if that's the passion that you have, if that's the litigation bug that you have inside of you, then I'm here to say, there are other avenues, one of which is either insurance defense or plaintiff injury, because it is just riveting stuff when it comes to advocacy.
All right, that's perfect, because now we can maybe learn more about the License Appeal Tribunal, especially from the insurance defense side, and perhaps maybe you can start maybe, kind of like, let's say if this was back in law school, it would be, like maybe a tort class or something on the lot, 101, let's say. So tell us kind of how it gets, or what's the process like before it even goes to lot on the insurance defense, or what's kind of the work that you do, and how it kind of transitions into something that may appear before the tribunal.
So I'll tell you, I really wish that I had a program like this one back when I was learning about insurance defense or plaintiff injury and stuff like that, because the reality is I learned it on my own. I had to kind of read about it. I had to ask colleagues, what is this thing? How do people do it? What is it all about? If someone had told me either in law school, or if there was a podcast, or if there was something that I could click on, it would have changed a lot of the work that I had to do. So first of all, kudos to you for putting something like this together, because I find this kind of stuff is invaluable. Law students all over need this kind of resource available to them. So, that in mind, here's how a file gets to me. In Ontario, you have to have insurance in order to drive a car. You can't be driving around a car uninsured. You have to have a basic policy of insurance to cover you while you're inside of a car. So the hypothetical goes, I have a policy of insurance, I have a car, I drive my car, and fate strikes me an unfortunate way and I get into a car accident. Historically or traditionally, we're trained to think, well, that means I got to go sue the other guy and that other guy's going to pay for my medicals. That's not how it works in Ontario. That might be the case in the United States. That might be the case in other jurisdictions. But if you want medical treatment, or let's call it attended care, let's say you're injured significantly to the point where you need an attendant to take care of you, you don't get that benefit or you don't get that service from the other guy's insurance company. You go to your own insurance company for that. So let's say I get into an accident and I am so injured that I have to take time off work and I need supplemental income replacement right now because I don't have money coming in. I'm not working, so I need income replacement. My own insurer is the one who's going to provide me with income replacement benefits, not the other person's insurer. So that, in a nutshell, is first-party insurance. It's my own insurer. When a file gets to my desk is, let's say, John Smith is involved in a car accident. He suffers injuries to his neck and his back, and he has some psychological difficulty as well. And he tells his insurance company, insurance company, I need chiropractic massage. The insurance company says, you know what, that's reasonable, that's necessary, we'll pay for your chiropractic massage. Then he says, insurance company, I'm having a hard time getting into my car, I'm feeling very anxious, I need, driver anxiety therapeutic sessions. And the insurance company goes, well, that's reasonable, that's necessary, we'll pay for your psychological therapy. And then John Smith gets a little greedy and he goes, you know what, insurance company, I need a 70-inch flat screen TV because my vision is just, I don't know, there's something wrong. I need to see my Sunday Night Football on a much better screen. I want a big screen TV. Now I'm being hyperbolic, but there's a request that's made and the insurance company goes, you know what, that's not reasonable. That's not necessary. We're not paying for that. And it's in that moment when the insurance company says, we're not paying for that, where John Smith now has the ability to say, I disagree with the insurance company's decision. I want to force you to pay me that benefit. And the venue that they go to in order to get that dispute resolution is the License Appeal Tribunal. So John Smith will say, you know what, I really wanted that therapeutic iPad. The insurance company said it's not reasonable and necessary, and they've denied it. I'm now taking that denial and I'm going to go to the License Appeal Tribunal and I'm going to try and convince an adjudicator that that iPad is reasonable and necessary. And the file comes to my desk when I get it and I see, hey, we told John Smith that he couldn't have an iPad. And here are the reasons why. And here's John Smith's entire medical history. And here's our medicals that we have on John Smith. And here's some of the supplemental things that we have. Sometimes we even have surveillance on John to kind of see what John's been up to lately. We have all this information and I get the file. And typically what any lawyer will do or any paralegal will do is you read the file from beginning to end to get an understanding of the chronology of events. What type of accident was it? What type of injuries were sustained? What's been John's treatment history? What's John's pre-accident history? We want to know what, did he have pre-existing conditions that make it worse for him? Did John have another accident that we don't know about that should probably be the one paying for the iPad? There are all these things that we have to know. So you do a gathering exercise. You gather all the information you have, and then you digest it and you process that information. And once you finish processing that information, you write a legal opinion. And so that's literally one of the first things that I do when a file comes onto my desk is I gather all the information, I review it, I process it, and then I write a legal opinion to my employer or to my client. And I say, hey, I think that, and it can either be you made the right call in denying that benefit, or hey, you know what, you kind of made the wrong call and you probably want to maybe settle this because you don't really want to take this to a litigation setting. And then the process progresses and I have conversations with my clients and we have to formulate trial strategy. So from the moment a file comes onto my desk, I'm already in trial strategy mode, which if you asked first and second and third year law student or lawyers, not even law students, first, second year, third year law student or lawyers, they would kill for that kind of interaction. They're not even within 100 yards of trial strategy rooms when you're in your second year as a lawyer. You're the guy in the windowless room doing research, trying to figure out, some obscure area of law. You're not in it. But a file comes onto my desk, and one of the first things that goes through my mind is, will we be successful if we take this all the way to a hearing? And that's intoxicating, because you're not worried about secondary noise. You're thinking about trial strategy. So I have a call with my client, and we formulate a strategy. Hey, I think we should defend this. I think we should have this person as a witness. You know what else I think we should do? I think we should engage a private investigator, and we should have an investigator surveil John, because I don't think John's doing what he says he's doing. I think John might be hiding the fact that he goes to the gym 5 times a week, and he hasn't been truthful with us. All of that is bounced back and forth with the client. And so after we have that conversation, a decision is kind of made, or a conclusion is made. Hey, you know what we'll do? We're going to defend this thing. We're going to see how we do. And then we take it through the litigation process. And the License Appeal Tribunal, just like any other court of law, has kind of an ADR, alternative dispute resolution process baked into it. So before you even get to a hearing, you have to do what's called a case conference. In the court setting, it's a pretrial, but we call it a case conference at the tribunal level. And the tribunal case conference is set to accomplish a couple of things. One, can the parties actually settle this? Maybe we don't give John the iPad, but he also had a claim for, assistive gloves or something along those lines. Maybe we don't pay for the iPad, but we pay for the gloves. And maybe John accepts that we're not going to pay for the iPad and we're just going to pay for the gloves. And Bob's your uncle. We don't have to fight anymore. We've reached an amicable resolution. So the case conference allows for that opportunity to maybe mediate and figure out, hey, who's gonna maybe make a concession here. So again, we're at the tribunal level, but I've already started working on trial strategy. Now I'm flexing my negotiation muscles, because a lot of litigation involves negotiation, because you have to figure out whether or not this is a file that needs to settle or needs to be defended. So I've done trial strategy. I'm now negotiating in a mediation type setting. And if we're unable to settle at this case conference, we set the matter down. You pick dates, you iron out procedural things like, when am I going to get your productions of evidence, and when am I going to disclose my production of evidence? How many witnesses are you going to be calling? How many witnesses am I going to be calling? If there's a motion to be held, then there will be a motion to be held. I didn't like the way so-and-so said he was going to call that guy. I'm going to resist that. That guy now brings a motion against me to compel that witness to testify. We're already arguing motions. Again, in your first, second, and third year out of law school, or as a lawyer or a paralegal, you'd kill to argue a motion. That type of experience you'd never get. The tribunal level, it's almost second hat. If there's procedural issues on a complicated file, you're most definitely going to be arguing a motion. So you argue your motions, you set your production delivery dates, you set your arbitration briefs, the final documents you intend to rely on. You pick out your witnesses, who you're going to call and who you're not going to call, and you're going to review their witness list, and then you get ready to go to a hearing. And that's where the fun begins, right?
All right, so let's just go right into the fun there. So what's the hearings like? And I guess obviously over the last couple of years, maybe a little bit different than previously there. So maybe you can talk about that as well. And I don't know if the switch now coming back, as we slowly say, COVID disappeared over the weekend last weekend, so back to normal. But maybe you could tell us a bit about that aspect of it as well, and tell us more about how the hearings work.
So the hearings, you're right. COVID did change a lot of things. Before COVID, the hearings were very much similar to that of a courtroom. The difference is the formality. So in a courtroom, you're gowned. You're wearing your tabs. There's certain formalities and procedures that are in place. Documents have to have a certain color of a cover letter, a cover sheet on them. It needs to be bound in a certain way. There's a lot of technical formality at the court level. At the tribunal level, there is still very much the substance of a court baked into it, but the formalities are less. So you're not gowned. You can wear business attire. So typically I would be wearing a suit and tie, the documents are still bound, but there's no color requirement, but you obviously have to be collated and tabbed, and you need to make sure that your documents are easily accessible and readable. Afterwards, the basics of, there's a witness box, that witness is sworn in, there's a cross-examination, things of that nature. People can object, their objections are overruled or sustained. All of that takes place as well too. The difference is, I guess, the formality. You're not in a formal courtroom setting. Sometimes I've argued a insurance first party defense case in a conference room of a hotel. They set the chairs up or the table up on one end, so the adjudicator sitting on one end, and the two parties are sitting on the side by side on the opposite side, and you're just doing it in a kind of a neutral setting. Then COVID hits, and we're not allowed to go anywhere. We're not allowed to have any type of physical interaction, and so the tribunal had to turn on a dime and now figure out, what are we going to do with all these in-person matters. Well, the one good thing that the tribunal already had working in its favor is that it had options to handle matters in different ways. So at a case conference that I described earlier, you can set a matter down to be heard entirely in writing. So you don't even do in-person components to it. You don't even call witnesses. You just hand a stack of your submissions over with your evidence, and the other side hands their stack of submissions over with their evidence, and an adjudicator reads both and goes, you know what, I like this one, and a decision is rendered. So you could do it in writing, so there was that built into it. The tribunal also had hybrid versions of a hearing. So you do that submissions, you do the written component, but then you call in over the phone and you do either a cross-examination of one witness, or if it's a very relatively short matter that involves oral closing submissions, you'd call them in and you'd read it, or you'd say it over the phone. And then there was obviously the in-person component to it. But the reason why I bring that up is because the tribunal already had avenues to kind of funnel people into to try and alleviate, hey, what are we going to do with all these in-person hearings? And some of them got converted into writing only. I know a few of my cases that were originally supposed to be heard in person have switched over into writing only. Some of them got converted into hybrids, which had writing and telephone. And then the vast majority of them turned into what we're doing here, which is a video. And the video component of it was a learning curve because, the littlest things turned into problems. What is the internet connection on? Is my witness not on mute? What am I going to do with that? There's a control element that you lose, but there's also a comfort level because it takes away some of the pressure and the feeling of stress that you have when you're in the room and you feel that kind of energy. You're in your home or you're in a conference room by yourself, you kind of get a little bit more relaxed. So there's a benefit to it in a certain extent. But, for me, I've enjoyed the video part of it, but I can't wait to get back into an in-person setting. I know the tribunal will probably want to steer more parties towards the video side because of resources and ease. But, for complex cases, for cases that really involve some legal nuances, I hope and I assume the tribunal will allow us to go back in person if the parties agree and request it. It's a very important component to advocacy. I think, obviously, where possible, we can minimize strain on resources. I'm all for it, but at its heart, advocacy is in person. Advocacy is, I'm going to present my argument in front of somebody, and my counterpart is going to present their argument, and he or she who has the best argument is going to win the day. And I love that about it. And so I'd be very disappointed if I find out that the tribunal eliminates it. I don't think it will. I think there are constitutional issues to that as well too. So currently, I believe the situation is still video as the only resort for in-person, but fingers crossed, if we get out of the woods sometime soon, although I've been saying that for the last 2 years now, if we can get out of the woods, we will get back to the in-person component of it, and we can kind of feel that the embrace of that pressure again.
That's great. And certainly, in attacking maybe credibility, or now you have John Smith there and you have your surveillance guy come back and say, what, actually, he is up at the club oh, well, I guess not now, but he's at the gym or something, and we got that footage, and you want to question him. But it's a lot easier to do that when he's in person, or even just walking to the witness booth, right? You'd be like, hey, I had no problem there.
I absolutely agree, JP. One of the questions that I used to ask, maybe I'm giving away some of my tips and tricks, but one of the questions I used to ask, the hypothetical John Smith is, it says here in your file that you say you can't sit for 20 minutes without, your back causing you any difficulty. And John Smith, who may not be the most credible or scrupulous person, says, yes, my back is always troubling me. I can only sit for 20 minutes and then I'm in excruciating pain. And then I'll say, well, did you know, sir, that you've been sitting here for the last 40 minutes and you haven't had any issues, or you haven't made any complaints about your back at all? And that's when you get to really see the theatrics, because John will get up and go, oh my God, my back is killing me, and this, that, and the other. And, I miss that, right? In video, he can just do this and say, oh, you don't know what's going on behind the screen. So, you're right. Credibility is one of those things that you really want in person, but, we have to adapt. We have to learn. I think you had a colleague of mine, Neil Wilson, on the podcast, and I know Neil from my days at clerking. He and I were clerks together, and he's a big advocate of technology advancing in the courtroom setting and using technology to kind of streamline courtrooms and make things more efficient. So I am not one of those fuddy-duddies who say like we have to have it in person and we always have to be, but I do think that there is something to be said about having that in-person component, because at its heart, I believe that's what advocacy is.
Now, you shared a little tip and trick there for us. Anything else there for students who want to get into insurance defense, or now thinking, hey, there's the tribunal? And certainly for my paralegal students, it's an area that's well within their scope.
For sure.
From the insurance defense, I don't know. I think tended to skew maybe a little bit more. Maybe I had more friends in personal injury. I don't know, but what's different about being on the insurance defense? I mean, when you look at your counterparts, let's say, and they're coming to argue for their clients' rights and how they should be entitled, and they always frame the insurance defense companies as the people that are just like tightening the purse strings there. They don't want to get up. What advice would you have if someone wants to go on that side, and how is it any different maybe when you compare to those on the other side?
So you're right. There is a bit of a stigma attached to the insurance defense lawyer. Whenever I used to describe it to family members or my non-legal friends, is I would describe, jokingly obviously, but I would describe it as, those suits that Erin Brockovich was up against, and she was always trying to fight the good fight, but there was always like this army of lawyers that were going to say, no, Miss Brockovich, you're absolutely wrong. That's kind of the persona that the insurance defense lawyer has, is like, everything you said is wrong and we're not going to do it, right? That's the obviously satirical version of it. But realistically speaking, the difference between plaintiff injury advocacy and the insurance defense advocacy, if I had to draw a line between the two, is my counterparts in the plaintiff injury side of things have a lot more humanity that they have to deal with. Their client is someone who is seriously injured. We joke about it, and I say John Smith may not be that, but the reality is that there's a large, vast majority of clients who are seriously hurt in car accidents or motor vehicle accidents of some kind, and those people need help. And I'm not here to say the insurance company is perfect. Mistakes are made, decisions are made that are inaccurate or incorrect, and those mistakes or those decisions need to be corrected. And that's where the plaintiff injury law firm has to kind of step up on behalf of their client, because their client may not be in a position to do it. They may be hurt. So there's a lot of humanity and people managing skills on that side, because I'm sure my counterparts are going to have to deal with their client saying, I really need that, personal support worker. When is that personal support worker coming? And that lawyer or that paralegal is going to have to say, like, I'm working on it. I'm trying to negotiate with the insurance company to see what a proper rate is. So that's the humanity side of it. For the insurance side of it, it's a little bit more, I don't want to say it's a little bit more stark, because there is a people element to it as well too. Like when I get a file, I'm not looking at it as a number and cents, because I'm sure the narrative is, oh, the insurance company just views people as a pile of money, and how much money is it going to be worth? No, That's absolutely not the case. I read cases and I get emotional about it. I see, this person has no business being in front of a courtroom. They should be getting help that they need. So the difference is mine is more of a corrective lens. Mine is a reviewer lens. I review what the insurance company has done, and I review it to see if it passes kind of either the eye test or the smell test, and then I review it for the law test. Like, does this make sense? Does this decision by the insurance company actually fulfill the legal requirements that are needed in order to be a successful denial? Or was a mistake made? Or did the company didn't have the appropriate information at the time? I can't tell you how many times that's happened, where a decision is made, John Smith, you're not getting this. We're not paying for it. And then a file comes to my desk and I have a opposing counsel phone call, or I'm talking to the paralegal on the other side, and the paralegal says, Mohamed, I just requisitioned the hospital records at Humber River. This is the evidence that I'm going to rely on that shows to you that John really does need that information or that help. And the paralegal will give it to me. I'll review it, and I call my client up immediately. You'll never guess what I'm looking at right now. I'm looking at an MRI that shows disc bulge and a herniated disc that says this person shouldn't even be walking right now. So for me, the difference is we're more reviewative, we're curative. We want to find out and get it right. Whereas the plaintiff lawyer or the plaintiff counsel or the representative, their job is more of a human job. I want to get this. I want this for my client. So that would be the dividing line. I'm sure my counterparts are going to view it in a different light. That's the experience that I bring to it. I don't review a file that with the lens of this is going to be a no, this is not going to be. I view this as, did we get it right? And if you're thinking about, for your students and for anyone else, watching or listening, if you're thinking about insurance defense, the expectations are going to be not just the advocacy part that I was describing, but a lot of communication. You're going to need to be able to communicate to your client why they either got it right or they got it wrong. And it's hard to tell another human being you got it wrong, because that human being is going to be like, you don't know what I was dealing with. I found this, and this is the reason why I got it right. And you're out to lunch, and I have to write a letter, and I have to have a phone call, or I have to have a conference call where I have to, politely but authoritatively say, legally speaking, ma'am, you didn't make the right call. This is wrong. And so if you have potential, students who want to get into this field, communication skills, number one. Written skills, 1A, right? They go hand in hand. You can't have one without the other. You need to have that there. Whereas on the plaintiff side of things, interpersonal skills, I think, play a lot more of a role. You need to have that ability to show compassion to someone who is hurt, but at the same time, give that person confidence to know, hey, I'm fighting for you. And if I get you a result, you're going to like it. And believe in me, I'm going to take care of you, right? Like, there's a little bit more of a interpersonal humanity side to the plaintiff side, and there's a little bit more of a review curative side that needs to take place on the defense.
And on that, you're working as senior counsel there at Aviva. How's that different than, there's insurance defense firms that have, different areas of practice, or they do work for different insurance companies, right? So how is that different then? Because you may have that phone call or that email with let's not use John, let's use Paul then, and then you're gonna call Paul up 3 months later and say, hey Paul, you got it wrong again, right? No, it's almost like you're a Montreal Canadiens fan and just keep struggling here.
There's a nice little drive-by there,
So how do you deal with that in that aspect there? Differently with that rather than being a firm.
So, going back to kind of my trajectory, after I finished clerking, I went to an insurance defense firm, and I spent almost 5 years in the private practice, billing and having multiple different insurance clients. And that experience had two stark differences. One, there's something called the business of law that I like to say inserts itself into the practice. You're not only a litigator, but you're also a business person. and you have to build your time, or you have to generate revenue for the law firm. So the business of law also gets mixed up into the advocacy side of things. So when you're in a private practice law firm doing insurance defense, not only do you have to secure a nice result, but you also have to secure a nice relationship, right? So like when you said, if you're calling Paul and you're going to say, Paul, you got it wrong, you're going to have to say it very politically correct to Paul so that Paul wants to keep referring files back to you in order to keep the money in the business of law moving. So that's one difference between private practice and in-house practice. And the second difference is the cost. So you mentioned it many times. There are different clients for when you're in a law firm. You have multiple clients. Each client is doing a cost-benefit analysis. Do I pay Mohamed his hourly rate to go argue for 36 hours after a week-long hearing to win this case for us, or do I just settle this file? And so when you're giving legal advice, you're also now giving business advice, because you're now putting together a table almost that says, this is how much it's going to cost you to run this trial, versus this is how much the other side will probably settle for. So in private practice, there's a little bit more nuance to how you go about achieving your advocacy, because the business of law inserts itself. One of the best decisions I've made, if I can be so bold, is to go in-house. And the reason why I say it's the best is because as a person who just values advocacy and litigating, I have effectively removed the business of law from the equation. I don't have to worry where my next file comes from. My employer is my client because I am in-house at the firm. So the firm is going to give me that file by virtue of my employment, not because Mohamed is that guy who treated me to that steak dinner the other night, or we had an agreement on the golf course that the next 30 files are going to come over to Mohamed. The business of law is no longer involved. I'm hired because of my competency. I'm hired because of my skill, and a file is referred to me because there is an implicit trust that I can do the job. And so for prospective students who are thinking about this trajectory, there are many, many people who love the business of law. They're the movers and the shakers. They want to go there. They want to press the flesh. They want to, wheel and deal, and they want to build a practice. There's certainly a lot of money involved in it, because if you build a small little empire in terms of clients, you make a ton of money. But if you're a purist and you want to just be that lawyer who does the actual advocacy, in my opinion, then in-house is the way to go, because they strip away kind of the secondary considerations. And my only concern when a file comes on my desk is, should we litigate this or should we settle this? There's no, is the partner going to like the fact that I settled this too soon and I didn't bill out a lot for it? Or there's no, I billed a lot for this. Is the client going to refer another file to me because I billed so much on this previous file? We've stripped that away. And so for prospective students, you have to find what motivates you. Do you like the wheeling and dealing? Do you like kind of the networking component of law? Because if you like that, private practice, you're going to love it. If you want to move that out of the way and you want to focus specifically and zero in on kind of the advocacy work, then in-house might be the way to go. And for paralegals, I can tell you there is a market in-house for paralegals and in private practice. Not only do the clients think that paralegals can do the job and do the job well, there is a business case for paralegals to be doing certain types of accident benefits files. Those are the type of files that I do, is accident benefits file, because there are multiple tiers. There are minor injury cases, there are not so minor injury, there's catastrophic cases. So it doesn't make sense for a senior counsel to be doing a minor injury case. But it does make sense for perhaps a first-year paralegal to, because they have the training and the skill set to actually argue the case, and the experience matches the kind of area of law. And law firms have figured out that paralegals are a very good resource for that. And in-house firms, or excuse me, insurance companies who are building an in-house department, they have also figured out that paralegals can do that. There are some in-house firms who use paralegals not only as paralegals, but law clerks. So they wear multiple hats. My current law clerk is a paralegal. So she wears multiple hats. She's not only my law clerk, but she can handle files. She can take care of my calendar if need be. She can assist in a hearing. So she's relatively new. So I have a hearing potentially coming up in April. She will be on the video call with me in April because she's a paralegal. She can participate, and she can be my right hand when the time comes, or if I need her for any type of assistance. So, to your students and to other individuals thinking about it, there is a market. There is absolutely a market that I'm sure you and I, JP, when we were in law school, had no clue existed, not one bit. So, that's my 2 cents on that.
Perfect, Mohamed. And thanks so much there again for joining us today and chatting and telling us all about that. And again, I think the importance there, as you pointed out, is the more that people kind of know, the more you can make some of those decisions later on based on kind of seeing what that trajectory looks like, or different things in that trajectory as well, right? Maybe someone's going to leave this and say, hey, I'm going to go to law school. I want to go and clerk for somebody, or maybe someone's going to say, I want to go into private practice, or on the personal injury side, or on the insurance defense side, or as you said, if you want to go in-house, right? And then you can kind of look more in making those decisions and more purely about the legal issues rather than the legal issues, but is the legal issues rise to justify maybe the increased cost? Because I'm sure, there are some fluctuations, but your employer is going to say, well, if you think it's a great case to defend, then let's go and defend it. They're not going to think more so about the cost as much as if it was from a private practice perspective. And it's great to point that out as well. So thanks again, Mohamed, for joining us. Any final words of wisdom? I know you shared a lot of wisdom here with us. For anyone listening, students, young lawyers, paralegals, or whoever, about kind of your career trajectory, or more about the License Appeal Tribunal, or just the practice of insurance defense.
Sure. 2 years ago, I wrote an article in the Canadian Defense Lawyers newsletter about the 3 Bs to advocacy. And it was a play on words because they don't actually start with the letter B, but it was be direct, be professional, and be supportive. And in my view, not only just in advocacy, but in life, if you can, strive to hit those 3 Bs, be direct, don't sugarcoat or don't hide behind things, or don't be vague. Be direct in how you want to approach things and how you want to approach life, or how you want to approach argument, or how you want to approach submissions. Be direct. Be professional. Recognize that this is a small community. Lawyers and paralegals, it's a very, very small community. People know one another. People talk to one another. Your reputation matters. So it's important to be professional and actually present yourself in a manner that you would like to be treated in. And then the last one is be supportive. It's not okay to look down on others. It's not okay to view others as different, as in different classes or different tiers. I deliberately do not put the title senior in my LinkedIn because I don't like the idea of separating myself. I'm a lawyer, and I'm a lawyer with all my other colleagues in the legal profession. So I choose not to do that because I want to be supportive. People should be able to reach out to others in their community and get that kind of support, and not feel shame, and not feel kind of judged or nervous or worried about seeking that help. If you can ask for help, you can get help. And so 3 Bs: be direct, be professional, be supportive.
Perfect. So thanks again, Mohamed, and I think a great overview there of the LAT as well as insurance defense and kind of your journey there to get to that point. Thanks for taking the time once again. Thanks for everyone for tuning in, and take care, everyone.
Happy to do it. Love it. Thanks, guys.